Okay, this is a law dictionary, all right? Reasonable probability. Evidence that tends to support a contention. Reasonable probability is less than certain proof, but it is helpful in deciding a civil suit for damages. However, an accused would not be convicted of murder merely on the reasonable probability that he committed the act. Right. Let's say you're a sheriff in another jurisdiction and you got the emails because I emailed sheriffs in lots of counties, all the counties. And there's a reasonable probability that you know that it's a crime to violate the 5th and 14th Amendment of the United States Constitution. You know it's a crime to violate the Violence Against Women's Act because if I moved to any other county or any other state, they would have to enforce a protection order that was not issued according to the requirements of the law. Now, all it takes is a phone number to any sheriff that I would to move to, any jurisdiction, any county, any state in the United States. And when they know it's a crime to deprive the respondent of the due process rights of notice and opportunity to be heard before issuing a protection order, yes, then I can sue them for damages, civil damages. Now, there's a reasonable probability that any sheriff in any county of the United States that knows it's a crime to issue a protection order that has been used to obstruct my rights as an American citizen, that in a jury of my peers, after I sue them, then all I have to prove is they chose not to do anything. Now, somebody's often said, well, why don't you just move to a different county? Why don't I get in a car, okay, or hitchhike, or get to wherever I'm going to go? Walk into another sheriff's department and inform them of the crime of violating the Violence Against Women's Act. Why would I want to do that? All I have to do is email them the evidence of the crime. Now, I don't need to move from county to county and state to state to be able to prove the crime of violating the Violence Against Women's Act. All I have to do is provide RI.PDF. When they see that the respondent was not given actual notice, when they see that the petitioner did not sign the protection order, when they see that there's forgeries on those documents, then they themselves would be able to see it's a crime to issue a protection order that does not conform to what is the requirements of the VAWA. Now, I don't need to move from state to state and go to sheriff's department after sheriff's department after sheriff's department explaining why it's a crime to deprive the respondent of the legal rights that a respondent has. All I have to do is email them. Now, there's what's called reasonable man, and I sent an email about this. A reasonable man, someone who acts with common sense and has the mental capacity of the average, normal, sensible human being, as distinguished from an emotionally unstable, erratic, compulsive individual. In determining whether negligence exists, the court will attempt to decide whether the defendant was a reasonable person. Now, in a court of law, when I sue every sheriff in every county in every state of the United States, I get to have a jury of my peers, and since the amount is greater than $20, all I have to do is prove to a jury of my peers that they got the actual email. Yes, they read the email or they watched the video. And then when I sue them, a jury of my peers would say, well, what would any reasonable person, what would any citizen of the United States expect from law enforcement when law enforcement's informed of a crime? Any reasonable person, any citizen in any county or any state of the United States would expect a response from law enforcement when law enforcement has the evidence that my right to due process is and has been violated. They would expect law enforcement to respond and restore those rights, give those rights back to the citizen, and they would expect that protection order would have been removed. Now, you have to understand a reasonable person, just an average intellect, your everyday American citizen. I walk in, okay, Paul C. Budnick, Mr. Citizen, that has emailed hundreds of thousands of email addresses. That emailed approximately 500 email addresses earlier today that had 7 videos on it called Without Prejudice. I bring out the court instruction forms that say, well, the law requires. Now, any citizen, any reasonable citizen, the dictionary does differentiate from those that are unstable, emotionally unstable, compulsive individuals, those that are erratic. Those are not the reasonable citizen. Just the regular old reasonable citizen. In determining whether negligence exists, the court will attempt to decide whether the defendant was a reasonable person. Now, when you sue a sheriff, a police chief, when you sue any oath of office that has been elected or appointed to office, when I sue those that have refused to enforce the laws of the United States, all I have to do to prove negligence on the part of the oaths is that they did have the evidence. I was not given actual notice and opportunity to be heard, and they did watch the videos or did read the emails. Now, all the extraneous information that I might have put in an email, that's not really as important as ri.pdf. Now, when you read that the petitioner didn't sign it, I was not given actual notice and opportunity to be heard. To prove negligence in a probable cause lawsuit, all I have to do is prove that they, the defendants in every lawsuit, are reasonable sheriffs, mayors, governors, elected or appointed oaths of office, and they've acted negligently because of their refusal to enforce the laws of the United States. I don't think you understand the lawsuit.